Good morning, WTOB listeners. This is Dylan Greenwood along with Harold Eustache of Greenwood Law, and we're here to present you this morning For the Record with Greenwood Law. Appreciate you joining us on the program here this morning here on WTOB. This morning we're going to be discussing sentencing enhancements, and a lot of this came about in the 80s and 90s with three strikes legislation. It was a kind of a easy roll off the tongue saying that went along with this type of law that basically says if you have three prior felonies of some sort, then there's going to be some sort of sentencing enhancement. Now, the law in this area doesn't just apply to felonies anymore. It's been expanded beyond that. And there are state court aspects of this. So North Carolina has made laws specific to these types of enhancements for habitualism. And so has the federal government. They've done it in a few different ways. And what we're going to do today is we're going to talk about those, what they mean, how they operate, how courts look at it. It is something that I think from a legislative perspective, Harold, I think it's easy to present to constituents if you're a legislator.
Very.
In a way that you're tough on crime, and that if you've done so many other prior bad things before, then it equals the fact that you are somebody who is a habitual offender. I think you and I have both been in this job long enough to know that, one, that tag doesn't always get applied to somebody just because they have three prior felonies.
Of course not.
And I think we've also seen instances of where it has been applied and it feels a bit harsh.
All right. No, that's true. And so I think one of the first things you said about it not always being applied, I think our viewers need to understand that it's certainly not always applied. There are many, many people out there who have been convicted of more than three felonies on separate occasions and are not given the tag of habitual felon. It is a separate thing. It actually has to have a separate indictment in order to have that. So just sticking with the way that courts have justified getting this type of enhancement under the Constitution, and so it is important to know that status crimes or being something can't be a crime necessarily. So think of it this way. If you are high from a drug or you are intoxicated, there's no real crime for being intoxicated or high, but there's the crime of intoxicated and disruptive. You have to do something. There's a crime of possession. But just being that thing is not the crime. So the habitual felon status, it is a status, but the way that the courts have determined that it can be constitutional is if it is hooked on to the proceeding of a substantive felony. So you can't, what can't happen is you can't have, 5 prior felonies and then, 3 years later, law enforcement or a prosecutor decides to say, I'm going to habitualize you. It has to be attached to some substantive felony in order for it to proceed. And again, it's a sentencing enhancement. So essentially what it's saying is at the end of some proceeding to say someone's guilty of a substantive felony, and then that they have an indictment, a separate proceeding to habitualize them, and a jury will determine that, and then at the end of that, they get an enhanced sentence for the underlying felony, and that can vary depending on what type of habitual offense we're talking about. And there's several of them.
Right. So if it's just habitual felon, like the generic one, you've got to have 3 on your third felony. You can qualify. Mm-hmm. So you have to have 2 prior ones. So let's say that you went on a crime spree. You committed like 5 felonies at one time, and you got arrested, And whenever that was taken care of in the court system, it all got taken care of on the same day. That wouldn't necessarily qualify. Like the next go around, you wouldn't necessarily be a habitual felon. You have to have separate arrests. Stuff has to be done on different days. You have to have different conviction dates for it to qualify. And then you could look at the possibility of someone being a habitual felon. Now, this can play out in a couple of different ways. And you kind of alluded to them, Harold, but one of the ways it could play out is if you plea. So if you plea and the state of North Carolina has already alleged that you are a habitual felon through an indictment, and that has to go to a grand jury, and a grand jury, is kind of this mystical thing that's out there of people who determine whether or not you have certain charges against you in superior court, but it goes before the grand jury, and the grand jury determines whether or not you are a habitual felon. So at that point, when we're with a client and we're looking at what's called their plea transcript, and you got to go through all these different questions with somebody, and you tell them what they're accused of, what they're pleading guilty to, what it's being sentenced at, and all of a sudden the focus is what the substantive crime that they're pleading guilty to. So let's say it's obtaining property by false pretenses. You're pleading guilty to that crime. However, it is no longer being sentenced at its normal level. It's being sentenced 4 classes higher. And that's generally how it works for a habitual felon. It's a 4-class enhancement for somebody. The other way that this can play out is through a trial. And at this point, it is typically a trial in front of a jury. Although it does not always have to be. You can have a bench trial in superior court. But let's say someone is accused of a crime. We'll say at this point it's felony possession of marijuana. And they have alleged that they're a habitual felon. They're found guilty of that possession of marijuana. Then after the jury returns a verdict of guilty, there is an entirely separate proceeding as to whether or not that person is a habitual felon. And the state of North Carolina has to prove beyond a reasonable doubt those prior felonies, the dates of which they occurred and they were convicted and all that sort of stuff. And then at that point, the jury determines whether or not they're habitual felon status. A lot of times once it gets to that point, it's kind of done. A lot of times it's stipulated that someone's a habitual felon if it's already been alleged. But if there really is a question of it, I have seen it challenged. But the way it plays out is, one of those two ways, and it means a 4-level enhancement. But Harold, general habitual felon stuff like what we just talked about, that's just one aspect of this whole thing in the state of North Carolina.
Yeah, there are many other types of habitual offenses. Habitual felon obviously is a serious one with 4-level enhancement up to C. And you have violent habitual felon, you have armed habitual felon, you have habitual misdemeanor assault, you have habitual DWI, and habitual breaking and entering. So there are many different types of habitual crimes you can have in North Carolina, and each one of them is frankly different in the way that they are applied. So I know that we mentioned one important difference is I know that we mentioned with habitual felon, on your third, you would have to have at least 3 prior felonies. But for something like violent habitual felon, it's on your second, so it's a 2 strikes, essentially law. There, on your second violent felony, you could be determined to be a habitual violent felon. And if you were determined to be a habitual violent felon, that instead of having 4-level enhancements, that would carry a life sentence. So it's very, very serious in that sense, because of the punishment there.
So Harold, the way the law defines a violent felony is that it's any class A through E felony.
Right.
But not all class A through E felonies are inherently violent, are
right.
they?
We were just talking about this, and I think the legislature wanted to make it very neat and clean and say, well, all these very serious felonies, A through E, are violent. are determined to be violent and can be used as predicating felonies. But for example, a Class C felony like embezzlement over $100,000, that is not violent, but would under this statute could be used as a violent felony because it's a Class C for a prior violent offense. So it's just interesting how that plays out. And another interesting one that comes to mind is also habitual misdemeanor assault, and that is one where you have to have 4 prior essentially assaults, but on the underlying assault that's being used to show that the person is habitual, there also has to be evidence of an injury. Which isn't necessarily true for the other convictions prior to that. So you could be convicted of some sort of assault where there wasn't evidence of an injury, but on that actual conviction, you've got to have that evidence of an injury to get to the habitual. So there's just some interesting things there. And another one that we deal with is habitual DWI, and that's interesting because of the difference between habitual DWI and then the A1 DWI.
Yes, because habitual DWI gets it up to that felony area where all of a sudden you're a convicted felon. A1 DWI is a specific type of aggravated level 1 DWI, typically because you have a child in the car. And so it is different. I think it's very possible to have, not that driving while impaired is ever, good or ho-hum or whatever else, but you could have 3 relatively low-level, just kind of innocuous DWIs that happened with somebody that, didn't involve an accident. No one was injured. It was a 1-car thing. There was no child involved, no person of reduced mental capacity.
Spaced out in time.
Just like completely spaced out. And then all of a sudden, they could be habitualized and therefore be a convicted felon. What's interesting too is on these habitualizations of misdemeanor offenses, all of a sudden, if you have a certain type of record, you can be double habitualized.
Oh yeah.
And I've seen that plenty of times. In fact, I've seen that with habitual DWI. I've seen it with habitual DVPO violations. And I've seen it with habitual assault.
Yes, and that's really interesting and important. In fact, one of the School of Government articles talks about that. Could you be have some underlying offense that makes you armed habitual felon, and a violent habitual felon all at the same time, and you could theoretically. I mean, if the principal crime qualified, you could have all these different enhancements. I was just looking at the armed habitual felon enhancement. That's also a 2 strikes enhancement that has to involve not just a gun, like possession of a gun, like firearm by a felon, but has to involve the use of or threatening to use a firearm in the commission of this act. But it's a 2-strike status. So if you are convicted, you're automatically elevated to a Class C, and more importantly, there's a mandatory 120 months active time. So a mandatory 10 years of active time that the court really can't get you out of. So it's kind of a mandatory minimum in the sense. If you're an armed habitual felon. So again, each one of these carries different penalties. I know for habitual DWI, there's a lot of penalties as far as licenses and stuff like that in the future. So each one of these is different and can really, really change the outcome of the case. And a lot of times for us in our practice, the way that we see this work is in negotiating essentially with the DA.
Yeah, I'm glad you mentioned that, because that was something I was sitting here thinking. Like a lot of times, because all of these things, whether it's habitual felon, armed habitual felon, habitual DWI, whatever it may be, all of it is in the discretion of the district attorney's office. They're representing the state's interest in prosecuting a certain crime. And so it's within their discretion to say, yes, at this point, based off of your prior criminal history, this is, you're being labeled habitual on whatever it is. And what we see a lot of times is the threat of that can push someone's hand to potentially take a plea, because if they proceed to trial, this is how the negotiation typically works out. Mm-hmm. If you proceed to trial, we're going to pursue the habitualization of it. And so if you go for it, you're running a huge risk.
Right.
And I know I've sat across from many people that makes you think real long and hard about the plea and whether or not you're going to take it. And more often than not, people do. Sometimes they don't, but more often than not, people do, because it can be a significant jump in what happens from a penalty perspective. Like we said, just the general one can enhance a felony 4 class levels. Here's the kicker in all that, though, is it's because North Carolina is on structured sentencing. There's a sentencing grid where you line up someone's criminal history record along with the class offense level of whatever they're accused of. When you're doing habitual felon sentencing, the prior criminal history that's used to come up with the habitual felon aspect of it, it is removed to some degree from the calculation of the prior criminal history. It's not double counted. Mm-hmm. However, whatever else has been on your record before is counted. And so you can definitely be higher up in the chart still, even though some of those offenses got pulled out to be used for the habitualization.
So you could still be a level 5, level whatever.
Theoretically, you could. So you all of a sudden you're level 5, because it goes all the way up to level 6. You could be level 4, level 5, higher up in the chart, have a low-level felony that then is habitualized, and all of a sudden you're looking at going to prison for 20 years.
Yep.
Easy.
And that's what one of the things that we see in negotiations a lot is that habitual felon hanging over a person's head, a defendant's head. So it is really, really important. It's an important bargaining tool for DAs. It's an important aspect of this in our practice. It's something that we deal with all the time. And it's also important to note that as far as the prior offenses, it's not just in-state offenses. It can also be out-of-state offenses. And so the court has to look at, and when a DA is trying to prove that that was a prior felony, sometimes, of course, the language in other states is very different. And so it's up to a DA to prove that whatever that prior offense is an actual felony, but it can be used to habitualize somebody.
Right, and the other thing about habitual felon status is that once you're labeled that, if you get in trouble again, let's say you pled guilty to habitual felon, or you were found guilty of being a habitual felon, and you served your time and you actually got out, mm-hmm. and you committed another felony.
I know. Yep.
It is almost guaranteed that you're going to be habitualized again.
Yes.
I mean, it's already on the DA's radar. I've only seen it a couple of times where it has not been. And frankly, I almost fell on the floor when I saw, and you wonder if somebody didn't catch something, or maybe they were just having a really good day and were feeling quite generous. You don't know, because 99% of the time, once a habitual felon or once a habitual anything, you're forever that habitual
if
thing.
You commit another offense.
Yep.
And it just snowballs into, as you can imagine, more time, or potentially more time. So it is a very, very important sentencing enhancement, to say the least. Good morning again, WTOB listeners. This is For the Record with Greenwood Law. I'm Harold Eustache along with Dylan Greenwood. And this morning we've been talking about sentencing enhancements, and we've started off talking about them in the context of state enhancements with habitual felon, habitual DWI, habitual misdemeanor larceny, and others. But there are also federal enhancements.
There are, and there are two in particular that stand out. They're armed career criminal status and career offender status. And federal sentencing, just like state of North Carolina sentencing is structured, it's on a grid where you calculate criminal history points, and then you also look at an offense level. The federal stuff is parsed out more than the state chart is. The federal chart takes up a whole entire page, really could take up more than a page, honestly. But federal judges do have more discretion, thanks to some seminal cases that have come out to be able to deviate from that chart a little bit more than state officials do. That being said, there are these enhancements which, if and when they are applied, are very strict. So the first one being armed career criminal, and if you've been convicted of 3 previous violent felonies and then all of a sudden you're caught with a weapon, a firearm, then mandatory minimum 15 years if you are prosecuted in federal court. And that is an enhancement that comes down the pipeline quite a bit. You could have never been charged or convicted of anything with a gun ever before.
Yeah.
And the term violent felony, kind of like it is in state court that we talked about earlier, is a bit broad. There are breaking and enterings that count as violent felonies. And there's been a big debate about that because somebody may not have even been home, or there may not have been, just an overwhelming amount of force or any kind of weapon used, but it counts as a violent felony. And I think a lot of people can get surprised by that. And there are other examples of that, but that's the easiest one that comes to mind. The other one, Harold, is even, well, it can be more strict, but typically is, and that's career offender status.
Career offender status is a very serious federal enhancement that basically ups the ante quite a bit.
2 times.
Yeah, 2 times. So it takes you all, as far as the sentencing grid, takes you all the way to level 6, and then enhances the penalty from there. So it is a very, very serious enhancement that can send a person away for quite a bit of time. This is for both drug and violent offenses. So even if you have some possession or distribution amount of some sort of drug, be it even marijuana, that could technically make you a career offender. Yeah. And those previous felonies can be state or federal offenses.
And the way career offender status works is, especially like with drugs, because that's the main way in which it is applied, really. Federal sentencing, drug levels depend mightily on the weight that was seized or the weight that you were associated with, including the mixture. And so when you look at that, depending on the drug, there's different weight scales. Some have mandatory minimums associated with it of 5, 10, 15 years. And depending upon what the sentence is, then that depends upon your career offender level. So at a lower level, you come in at such and such career offender level, that all of a sudden, let's say you were a 22 on the scale, all of a sudden you're a 30-something. It's stuff like that. Again, the higher you go up, the bigger that jump is to amp up the career offender thing. Now, you get high enough, depending upon the weight of the drugs or whatever else, there are times, due to the way things are set up with our drug calculations, that the drug calculation can be higher than the career offender level. And the court, typically probation in the court, looks at the higher one. So whichever one's the highest. They don't give you the benefit of the doubt and go lower. They look at the highest one. And that came about in the 80s with the war on drugs.
Yeah.
There's a big push for all these big sentencing reforms. Since then, there has been more of a push as we've gone on for sentencing reformation the other way, to bring it back down a bit, because there have been there's been a mass incarceration that we've had in this country that has disproportionately affected certain populations.
Mm-hmm.
And these particular enhancements have done that as well, because I know I've seen some records of some people where they get to these statuses quickly and they go, well, all I ever had was probation. They just kept letting me out on probation. Then all of a sudden they get popped in a drug offense with a gun. They had a few prior violent felonies, and were let out on probation. Then all of a sudden
they're gone for 15 years.
Yep.
I mean, and that's where these federal sentences, and you probably heard in the news about how they are. Some people see them as unfair, but they're a vestige of the 80s and the early 90s, this war on drugs that we had, and how these federal sentences can be pretty harsh even for drug possession offenses. Thank you all for joining us on For the Record with Greenwood Law. Please join us again next week as we tackle another important legal topic in North Carolina. That's what we do here. We enjoy getting into the weeds on these topics, so please join us again. And Mr. Greenwood, would you kick off the Bill of Rights?
You got it, Mr. Eustache. First and foremost, I will not represent myself in a court of law. Second, I will not do law enforcement's job for them. 3, I will not make statements when stopped by law enforcement. 4, I will not consent to searches when stopped by law enforcement. And 5, I will not be my own star witness for the prosecution. Remember that Greenwood Law Bill of Rights. It's important to know your rights. It's not a crime to assert them at all. This is For the Record with Greenwood Law signing off.